Once again, welcome to you all to this Pathways Forum on climate litigation as a way of leveraging sustainability transformations. This is a session that's co-organized with the UNESCO Bridges Coalition, and Stephen Hartman, who's the director of Bridges, is with us today. Maybe I can let you give Stephen a brief introduction to the Bridges Coalition.
Sure. Welcome, everyone. It's great to be here today for the 11th Pathways Forum event that Future Earth has organized, and the second one that they've organized as a sort of a team up with the Bridges Coalition. And we had one earlier this year in February, and we're really enjoying this collaboration. And I've been particularly excited for a while now about the prospect of having this discussion today. Bridges is the humanities-led sustainability science coalition within UNESCO's Management of Social Transformations program. We have begun operationalizing in the past year and a half. We have more than 40 institutes and member organizations around the world, and currently 6 hubs, which give Bridges its implementation capacity. We're seen as complementing organizations like Future Earth, actually, by bringing humanities and the arts and educational sciences, for instance, among other sort of qualitative social sciences into productive or constructive dialogue with the sustainability science community that has come together under Future Earth over the past decade. And so Future Earth was actually important in the establishment of Bridges. It had a voice, and the Paris Hub in particular had a voice at every stage along the way in the visioning process that led to the establishment of Bridges 2 years ago. And so we are now taking forward our cooperation with them, as well as with a number of other sort of global and regional organizations that help us to meet our mandate and our mission to be bringing more fully the arts and the humanities, qualitative social sciences, and then also knowledge actors from non-academic knowledge domains into transdisciplinary collaborations, and we're there to promote those, as Future Earth is already doing as well, but coming together in ways that allow us to join forces and bring added value to one another. So that's the context behind the team-up collaboration that we built with Future Earth, which we're looking forward to moving forward with. And and so I think it's enough for now. I'll turn things back over to you, Yil, and look forward to moving into this really interesting topic.
Thanks very much, Stephen. And I also want to mention that we received support and help from Arizona State University through the Julie Ann Wrigley Global Futures Laboratory and the Mary Lou Fulton Teachers College. Yeah. All right, so let's get into the thick of it. Over the past 10 years, the number of climate litigation cases has been overall on the rise, and this is a trend that I think was particularly visible in the Global South. And you might already have heard of high-profile cases such as Milieudefensie versus Royal Dutch Shell in the Netherlands, Neubauer versus Germany, or Sustaining the Wild Coast versus the Ministry of Mineral Resources in South Africa. And these cases illustrate the role that litigation can play for citizen groups and communities when it comes to challenging structures of power, such as governments or fossil fuel corporations, and when it comes to holding them accountable for some of the governance or practices that are unsustainable. And given that judicial action are increasingly recognized as an important tool for mobilization and resistance, with this session, we thought that it would be interesting to explore how and to what extent litigation can support governance and societal transformations for better futures. So the plan for today is to explore a number of questions together. Some of the questions include how litigation's actions are contributing to change even when they are not successful. I mentioned a few successful cases, but it's not always the case, and there might still be value in pursuing legal actions despite uncertain outcomes. Do the actions resulting from climate litigation necessarily pursue justice and good outcomes for the climate system? And another question we wanted to talk about was the broader social impacts that litigations can have beyond the legal realm, I could say. And to help us critically engage with these questions, I would like to give a warm welcome to our speakers today, Joana Setzer from the Grantham Research Institute at the London School of Economics and Political Science. We also have with us Melanie Murcott from the Department of Public Law at the University of Cape Town, and Kelly Matheson, Deputy Director of our Children's Future Trust, a nonprofit public interest law firm that provides strategic campaign-based legal services to youth from diverse backgrounds in order to secure their legal rights to a safe climate. And to give you an overview of what's in store for today's session, we will kind of divide this webinar into two parts. In the first part, Joana, Melanie, and Kelly will introduce different entry points into the questions that I outlined previously. Joana will start by offering a more global perspective on these questions. Then Melanie will give us a more specific perspective using the concept of transformative constitutional regimes and using concrete examples from South Africa, probably. And then Kelly will offer the perspective that emerges from the Juliana versus US case. And maybe we'll talk a bit about the Youth versus Golf documentary also, which was related to the case, and the broader work that happens at our Children's Trust. And I want to highlight the fact that you can use the chat at any point during the presentations for questions and comments, and we will be able to take one or two clarifying questions after each presentation, but we can also save some of the more extensive or complex questions for the discussion that will happen in the second half. Because the second half will be dedicated to an open discussion where you will all be invited to contribute with questions or reflections or comments. You'll be able to share your experience and insights as well on this topic. And for the discussion, we're also very lucky to have with us Rebecca Fenn, who is a PhD candidate at the Tilburg University Law School in the Netherlands. Thank you very much for being with us, Rebecca. I'm very much looking forward to that discussion. So without taking any more of the discussion time, I'm going to stop here. And I would like to invite our first speaker, Joana Setzer. Joana, you can take the floor whenever you're ready.
Thank you very much, Giles and Stephen, and all of those involved in this and those who are participating. I liked how you started saying that this would be a reflective space. It really feels a privilege to be able to stop on a Friday in December to have a moment to reflect. So yeah, really looking forward to the other discussions. And what I have in mind is really to set the scene and give a more broad overview of what is happening, and then the other colleagues will bring more examples and richness to this discussion. So in terms of sharing my screen, hopefully this will work smoothly. And good. So I was asked to speak about, in this context of tools of climate change mobilization and resistance, climate change litigation being one of those. And Giles already said two interesting things, which I think I will even want to start with that. First, he said that litigation is playing a role in challenging the structures of power, and that courts are becoming governance actors. So I think that's a very good way to start, and I will maybe accept these statements and explain how they are happening, and maybe also to what extent they might not yet be happening so much. And I want to begin with this very, very new paper. It came out 3 weeks ago, and it's a paper that I co-authored with a bunch of colleagues from different disciplines, and from human rights lawyers to environmental climate and some political science as well. And what we are trying to understand is, it's precisely what I guess this conversation today is about, which is what is the role of courts, and what to what extent this is influential. So what we do in this paper, and it's included in the reading list for this conversation today, is that we looked at 5 interrelated domains where there is a potential for climate litigation, or for courts in particular to play a role. So what we're looking here is the idea that courts are playing an increasingly influential climate governance role. This is what we believe it's happening, and that they could be even recognized as Anthropocene institutions. So there's this idea that we are in a polycentric system with complex problems, and that climate law or earth system law could have a role to play. So I'm not going to go into the details of the paper, but I'm going to briefly mention these 5 interrelated domains of influence. And through the types of litigation that we have seen emerge, I will flesh out some of these. So what we argue in the paper is that these domains are first establishing a layer of accountability. Second, redefining power relations. So really back to what Giles was saying. Thirdly, that litigation and courts can help addressing the vulnerabilities and injustices that exist, especially with the issue of climate change. Focus on that, of course. Fourth, that there is an increase in the reach and impact of international climate law that is facilitated by litigation. And lastly, that litigation helps applying climate science and consolidated the science within legal disputes. So I will start by giving you the overview that I promised. And the overview comes from our Global Trends in Climate Litigation report. This is a report that at the Grantham Research Institute we publish every year. It's a co-authored report with my colleague Kate Hyam. And every year we look at the cases that have been collated, compiled by the Sabin Center at Columbia University, and we analyze what's happening, the trends, and try to bring our crystal ball out and see what's coming in the future. So what we see happening so far is that there's been this clear increase in climate litigation. We have now more than 2,400 even cases, the majority still being in the US. So you see here the orange bar is the majority of US cases clearly, but the rest of the world is growing in number, and also, I would say importantly, growing in the relevance of the cases and the types of decisions that we've seen. Vast majority of cases since the Paris Agreement, which is an interesting point that I will mention a few reasons why. So far, it looks like 2021 was the highest number of cases, but this always changes and it depends on data collection. So I think what really matters from this graph is that it's growing, and it's growing not only in the US, but around the world. When saying around the world, this map shows where it's growing, and here you see the US again in this dark blue, but Australia, some countries in Europe have seen an increasing number of cases, particularly Germany, UK, and in Latin America, Brazil has also seen quite a considerable increase. Global South still are behind, but Melanie will talk more about this. We also have now over 50 cases that are before international and regional courts, and maybe we'll have time to discuss some of these, the 3 now quite well-known advisory opinions. But it's the key message here is that it's happening domestically, it's happening internationally, still very much in the global north, but with an increase in cases in the global south. Now, I think it's important to keep in mind that we will be speaking about some of the most striking cases, and we'll hear about the Juliana and the Montana case, and the agenda case that is always brought into these discussions. But it's important to stress that not all climate litigation is a Juliana or an agenda case. There's a lot of litigation that deals with other types of issues, regulatory issues, clarifying some allocation of allowances within the EU ETS. So when we talk about the power of litigation, we're usually talking about a smaller subset of cases, which we try in our report to separate and say, look, there's not all first litigation is strategic. There's also the usual bread and butter litigation that happens with climate around climate issues. And secondly, that not all litigation that is strategic is aligned with climate objectives. There's also anti-litigation that can be brought strategically, such as we've seen in the US with the ESG backlash litigation. So hopefully this gives some general points that we can then continue discussing. In that same report I mentioned, our Global Trends report, we try to analyze the cases not based on the legal doctrines or areas of law, but in the strategy in what the cases are seeking. And this is again where we see that there are climate cases that are aligned with climate objectives, cases that are non-aligned with climate objectives, and something that I want to finish this short talk with, the complex gray areas that are obvious in any complex problems, which we've been calling just transition cases, which reflect the complexity of the issue. So giving a few examples of the government cases against governments, sometimes we refer to these as systemic cases, sometimes as government framework cases. And this is also where the Juliana case and the Montana, Held versus Montana, and many other very relevant cases that have been successful fall into. So what we see here is that these cases are creating that level of accountability that I mentioned in the first slide by seeking ambition and seeking implementation. So ambition is when there is the perception that a government is not doing enough. So the very classic agenda example, the Netherlands could do more. It's a wealthy country with possibilities of having more ambitious targets. And you have the court saying, telling the government, step up your ambition. Similarly, the Juliana and the Held versus Montana cases, seeking more ambition. And then we have implementation cases where the laws are there, the policy is there, and what is seeking is that these are implemented. And I think that these are mostly relevant so far, we've seen mostly in the Global South. So a few words about climate litigation in the Global South. I've written a paper, other colleagues have also already written about this, that it has a slightly different color and strategy that we have observed in such cases in the Global South. Most of these cases will deal with the poor enforcement of existing legislation, so the issue of implementation. Most of these cases, but also then many of the Global North cases have had this strong rights-based argument and have been very successful in showing that climate change is a human rights issue. And that has been a whole upgrade, I would say, to the whole discussion, because it really brings climate issues to that level of importance of protecting human life and protecting the right to health. And this is what we've seen in several of these Global South cases where there's been a stronger tradition in rights-based litigation. So it's an area where I think the Global South has even given, especially starting with the Ligari case here, a case brought in Pakistan that also has adaptation issues, all the way to the Brazilian case where the Paris Agreement was recognized as a human rights treaty. All of these cases have helped to give that face to climate problems, and also a level of importance in terms of what the courts and judges are dealing with. Many of these cases in the South also have linked climate with more pressing daily issues that these countries face, and I'm sure Melanie will speak to some of these. Now, from cases against governments, a few words about cases against corporates. This is an area that receives a lot of attention, but actually it's the minority of cases are against corporates still, but they of course have been a matter of concern because they deal with major emitters, but also companies that have a reputation that they try to protect, and these cases have been teasing that reputation. So the main types of cases that we usually see and we identify in the report are the polluters pay. So back to the old environmental litigation cases, the idea that the polluter should pay is being brought to these climate cases with cases that then will bring adaptation or loss and damage aspects to them. And this is what we see in the Saul Luciano Liuya case against RWE brought in Germany, and more recent cases such as the Tasmania versus Holcim, a case brought by 4 islanders in Indonesia against the cement company Holcim in Switzerland. So these cases also have that transnational component that is so necessary and intrinsic to climate litigation, but also that makes these cases quite mind-blowing, especially for a more traditional type of lawyer. So the Tasmania versus Holcim not only seeks that the compensation, but also seeks that change into the future of the company. So basically alignment with Paris, which was achieved with this very important decision. And you see there in the slide, the utterly excited lawyer of Milieudefensie the moment that the decision was handed in the Shell case in the Netherlands by the District Court of The Hague. So these are the alignment with Paris or framework cases that we see, not only looking at the fact that these companies have emitted in the past, but most importantly, that they need to change their future. The third type of case there, the turning of the taps, is a quite recent and very important type of case where there's the perception that you have to go to the source and stop the financing of these activities. And we've seen cases against BNP Paribas. Some of these cases also have the climate washing component, the fact that these many companies have been misleading or on purpose lying to the public in terms of how much they do and how much they invest in renewables, for instance, or simply not being able to demonstrate their net zero commitments in a way that is scientifically sound. So this is the world of, in a very short slide of litigation against corporates. But just to finish, when I talk about corporates, I gave here a few examples. There are cases against carbon majors that have been the majority. So this is a graph that I find fascinating. You see in the beginning that was the focus, but then you go forwards in time and you see how now there's a much wider diversity of cases being brought against corporations. So I mentioned the financial sector, but this also expands to the agriculture and airline companies, car manufacturers, etc. So we see this idea of systemic lawyering that my colleague Javier Solana talks about, where litigation is being brought against actors that are not just the visible ones, but that are crucial for the value chain, and this particularly with the financial ones. So now, in my very last few seconds before I finish, I want to remind you that there are also the gray zones. The gray zones meaning that not every case is aligned or non-aligned. We also see within climate litigation the complexity of communities that are being affected, that are already vulnerable and are being affected by policies that try to, for instance, increase the amount of renewables generated, but that are affecting indigenous communities and their lands. So this is what we've been referring to as just transition litigation. And then secondly, this is a new report that we published where we look at climate solutions, so markets and several other policies that are trying to address climate change, but that with the amount of funding and different interests involved, might also lead to an increase in corruption and integrity risks. So it's important to identify where these areas are and have enforcement authorities addressing those risks. To finish, the story of the impact is a complex one. You can see impacts on a more straightforward way in terms of, has the case aimed to is aligned and has it won, and this is what we do in the report. So we say, look, the result is a half-half, almost, that there's more with a more favorable slightly result towards outcomes that protect climate, so aligned with climate protections. But it's a more complicated story, as it was already anticipated. Sometimes, yes, you win in court, but sometimes you what Kim Bauer and I spoke about, fail with benefits. So you might lose in court, but still have some indirect contribution to climate action or open avenues for new cases. And sometimes you haven't won or lost yet, but you're shaping narratives. And I think Juliana has been a very powerful example, as well as UEA versus RWE, of cases that have taken a long time and still are ongoing, but have already shaped narratives. My very last slide talks about the ways to quantify this, and how we have seen, even, and this is a research that I did with colleagues at the Grantham economists, saying that some of the cases against carbon majors have impacted their firm value, so share prices drops as a result of litigation. So this is hopefully an indication of the types of impacts, the types of cases. Of course, have to mention that the last IPCC report recognized that litigation is a tool of governance. That was a big achievement. And if you haven't read the IPCC report and the summary for policymakers, but also the IPCC report itself, I highly recommend that. For the first time, that has been there, that mention. So now, looking forward to the rest. Hopefully this has set the scene, and I'll stop here for now.
Thanks very much, Joanna, for this this overview, which I think beautifully sets the scene for the rest of the discussion. We do have time for a couple of questions, if there are any amongst the participants regarding Joanna's presentation just now. Stephen, yeah. Or right, yeah, Raki, go ahead.
Yeah, so Joanna, thanks very much for that very illuminating presentation. And just in reference to the last slide that you showed us, or maybe the next to last, I can't remember which. How are you in your report, measuring impact or defining impact? I mean, so you gave us a couple of examples about leading, even if the case does not move forward, it still opens pathways forward. But I'd just be curious to know, for your purposes of keeping track of these cases, how you're defining impact.
Yeah, so thank you for this question. It's a very complicated one, because the first thing, before you say what impact, you have to define what impact is. And so the literature has, and this is the climate literature, but also human rights litigation and other types of strategic litigation, usually talk about direct and indirect impacts. So the direct impacts would be, you have the decision. So for instance, Urgenda, it determined the phase out of coal and investment in energy efficiency. So you can track that, how much the government has invested now into energy efficiency, and what is the government's plan to phase out coal. That's a direct one. Or with Neubauer, for instance, the legislation that follows the decision of the Constitutional Court. Indirect impacts, much more complicated. People talk about, for instance, the increase in the perception of risk. And this is something that you can only explore by doing interviews or collecting different types of data, where you start seeing, well, how is the narrative changing? For instance, one way to do this is to look at how courts in the beginning didn't accept the science so much, and now both the courts and even the carbon companies won't challenge the science in the litigation. So there are several ways in which you can perceive within the case and outside of the case the impacts. So the piece that we did on share prices is one example of trying to quantify. So most of the impacts are qualitative, but we thought, well, let's see if we can have a quantitative indicator that litigation would have. And my economist colleagues then run these event studies that can basically look at any event and whether that event has impacted share prices and what was the drop. So then we were able to quantify. So just to summarize the answer, direct and indirect impacts. The indirect impacts can be quantifiable or non-quantifiable, and they are of a really huge range of types of impacts.
Thank you.
Thanks, Joana. I see there's a question from Ajibola, but Raki also had a question before. I don't know, Raki, if you still want to go ahead with your question.
Yes, thank you so much. Thank you, Joana, for the presentation. My question is centered on the Global South from South Africa. So one of the main challenges that developing countries have is the implementation of policies. I was just wondering whether you had any insights on how we can overcome that challenge, given the fact that litigation is a lengthy process, and often we're already experiencing multiple adverse effects in our country. How can we overcome the challenge of implementing? Thank you so much.
Thank you for this question, and I wish I had the magic answer. I come from Brazil, where similarly implementation is a huge challenge. We have in Brazil the most beautiful pieces of legislation, perfect, written from the Constitution that grants future generations the right to a healthy environment, all the way to a broad range of pieces of laws and policies which often are not implemented. So I definitely relate to this challenge from from birth, and I try to see that in my work and through litigation as a specific angle where we're seeing that attempt to seek enforcement. So the problem with litigation, I would say in this regard, is that to an extent it would expose that failure in enforcing legislation. So it is helpful in perhaps from the filing document, the petition, to consolidate the message that a policy, a commitment is not being enforced, implemented. But this is still, we know, miles and miles away from the actual implementation. So one of the examples that is usually given and comes to mind now is in Colombia, one of the climate cases resulted in a successful court decision all the way from the Supreme Court of Colombia, dealing with deforestation in the Amazon as a source of emissions. Again, a beautiful decision that you would want to print and frame and hang it on your wall. But the fact is that even with that, the deforestation, the illegal deforestation in particular, didn't stop. So there is always going to be, if you look at the half-empty glass, even the most successful litigation won't give you the guarantee of that implementation. But then, on the full side of the glass, I think that, as I said, first, the mere filing of the case helps making that, especially if that point is communicated widely. So I would say litigation that demonstrates that poor or lack of enforcement implementation needs to be widely communicated, and it has to then involve actors beyond those filing the case. So the idea of community lawyering, I think that's really where it's important, that the case just helps bringing people together and help people and being able to speak to their politicians, to the community about what it means to not implement or what could be an implementation. So the litigation becomes really an excuse to create that community lawyering aspect. And then I think, finally, just a reminder that is always good to have, that litigation is just one tiny tool that is part of the toolbox. We keep saying that, but it's always important to say. So it's definitely not going to be the solution.
Thanks, Joanna, for this answer. And I think that Kelly, you wanted to also jump in and react to this question.
Yeah, I'll just be really quick. I just wanted to say, bring the cases. Joanna might be able to correct me on this, but the last count, there were 15 of those 2,000 cases, 2,000 plus cases in Africa. 9 of those were in South Africa. You've got the courts of the world having a voice in what's going to happen in climate change. And the continent of Africa, the courts just don't have the opportunity. So we've been talking to a number of different people about some ways to allow the judges down there to have a voice, but they cannot have a voice if the cases aren't brought. So that's all I wanted to add.
Thank you, Kelly. So I see that there's a last question from Ajibola, and I'm wondering, Ajibola, if it would be okay to save your question for the discussion time, just so that we can move ahead. Would that be fine, Ajibola?
Okay, it's all right. I'll save it. It's all right.
Thank you. Thanks very much.
Oh, you're welcome.
And so now we can move on to Melanie's presentation. When I can see that the presentation is already on the screen. Melanie, you can go ahead whenever you are ready.
Great, thanks very much. It's wonderful to be here. And building on what Joanna said, I'll be offering a South African perspective on climate litigation. So I thought it's useful to start doing so by reflecting on the link between constitutionalism and litigation, since many cases are rights-based cases, and those rights are often entrenched in constitutions around the world. And so what we see in constitutions is an embrace of the limits of state power, often through written constitutions, but not always. And sort of core features are the separation of powers, the rule of law, and respect for rights. But, and this is crucial, within different countries, these features play out in vastly different ways, and they can depend on factors like legal culture, history, politics, economics, values. So whether a country's values are primarily driven by neoliberalism, or whether they are driven by African values like Ubuntu, can fundamentally inform how constitutionalism plays out. And of course, this then impacts climate litigation in turn. And so I've sort of charted out, and this is very rough and ready research, constitutionalism as different models. This is not a time scale. This is what I consider to be different models and their evolution in relation to their ability to respond to the climate crisis. So we have these kind of very Western liberal models that are focused on preventing state interference with individual rights, so a big focus on privacy and freedom of speech of the individual. Then we have elsewhere in the world, especially in the global south, a number of post-liberal, post-colonial constitutions where there's a greater emphasis on socioeconomic entitlements, the obligations of states to play a positive role in delivering those, and obligations on corporations to play active roles as well in protecting and enforcing rights. And then relatedly, there are many constitutions around the world that have entrenched environmental rights, so have started to protect the environment at the constitutional level. And more recently, constitutions that have started to include climate protection. Then, building on these last 3 things, there are theories that are emerging about how constitutions can work in practice. And one of them is my own, is transformative environmental constitutionalism, where I recognize that the South African Constitution protects the environment, but it also has at its core a call for social justice. And I say that we have to bring those two ideas together in this time of planetary crisis, and courts are increasingly doing so, so as to address intersecting vulnerabilities and intersecting axes of oppression and marginalization. And so I highlight various ways in which the Constitution of South Africa, and potentially transplantable to other constitutions around the world, is able to do this. Then lastly, we're starting to see constitutions around the world recognize rights of nature, put a lot more emphasis on indigenous people's rights and self-determination, acknowledge the precautionary principle. And so there's that new wave of constitutionalism. So this is just a real snapshot, but it fundamentally influences the types of climate cases we're seeing and what lawyers can do in different jurisdictions. So what Kelly was just saying about the idea that we can, South African courts can do a lot, is informed by the fact that we have this particular model of constitutionalism, and the power that we have there needs to be untapped. So what are some of the categories of climate litigation we see in South Africa? Well, Rodriguez, Garavito, and Gallant, in their very recent hot off the press article in Constitutional Court Review, have categorized South Africa's climate litigation into 3 camps. So the first is challenges to fossil fuel power plants. And an example of this is the EarthLife Africa case, where a coal-fired power plant project was reviewed using administrative law alongside all of those wonderful rights and values in our constitution. And the court found that climate hadn't been properly considered. Climate was a relevant consideration, even though not in the law, not written in the law explicitly, and reviewed and set aside the approval of a fossil fuel power plant. We also have challenges to fossil fuel exploration and development, and this is going to be ever more important as we see fossil fuel companies flock to our shores to explore for oil and gas. And so we've seen cases where exploration for oil and gas along the coast has been halted through injunctive relief and then reviewed and set aside on the basis that it was unlawful, didn't include adequate participation, didn't respect indigenous people's rights, which are also protected in the Constitution, among other issues. And then more recently, and an ongoing case I'll touch on later, is a challenge to government policy that seeks to rely on coal in spite of its climate commitments. And that's youth-led litigation that is seeking to hashtag cancel coal in the country. So those are kind of the 3 broad categories. There are others. Now, in the Global South more generally, but including in South Africa, we see climate litigation often being used as a response to racial capitalism. And of course, this is because, and those examples and categories really speak to that, right? So we're seeing global multinational corporations coming into the country to extract, to oppress, to marginalize, and all the while exacerbating the climate crisis. And then we're seeing many grassroots communities respond with litigation and other social movements and try and keep these fossil fuel companies at bay. And this is, they're doing so because of the responsibility for climate change being largely at the feet of these multinational corporations and the states that benefit from the profits they make. And at the same time, the communities who are bringing this litigation are least responsible for climate change, but will suffer the most as a result of it. And so the litigation exposes systems of oppression that are contributing to our ongoing socio-ecological crises. And these include colonial and neo-colonial conquest, dispossession and imposition of this global capitalist order that we really saw moving and shaking at COP28, that systematically abuses nature and exploits large segments of the world's population. And so I wanted, sorry, I've just gone back. I want to just highlight these north-south dynamics. And in doing so, I want to point out that the way we define and understand climate litigation is also evolving all the time. The cases Joanna highlighted adopt a climate visibility approach. There's a growing movement in South African scholarship and African scholarship indeed, that approach to understanding and categorizing climate, very legitimate, very important, isn't well suited to an African context where our litigation addressing climate issues is mainly about risk. So the research of Tracy Lynn Field and others illustrates there are many cases about drought, many cases about projects that don't explicitly mention climate. So they don't make climate visible, but they are fundamentally about the climate crisis. And so there's ongoing work to redefine climate litigation, to adopt a risk approach or risk understanding and bring those cases into the spotlight so that this idea that climate litigation isn't happening in the global south can sort of be interrogated with reference to what kind of litigation is happening and why is that kind of litigation happening. Then within that visibility approach, we have several cases. I've already mentioned some of them. So Earthlife overturning a power plant, a new coal-fired power plant, the Sustaining the Wild Coast litigation, challenging an exploration right to explore for oil and gas along South Africa's wild coast, Philippine Horticultural Association, where an urban development was resisted because impacts on an aquifer that support farming in the area were not properly considered in the context of climate change. And then there's what's known as the deadly air litigation, one of the disappointing examples because it's been appealed, but it was a brilliant judgment in the first instance, where government's been ordered to put in place regulations in a highly polluted area of South Africa, polluted due to coal-fired power that emits greenhouse gas emissions. So these are some of the examples where we've had positive outcomes on paper and to some degree positive outcomes in practice as well. And I'll turn to some of the positive outcomes in practice. So highlighting for now some of the positive comments on paper, the judge in Earthlife Africa introduced a duty to consider climate impacts when new developments are approved by the government. And this was the first case in South Africa in which that happened. The duty doesn't exist in hard law, but the court interpreted that law with reference to the constitutional context and established that such a duty existed. And that duty has since been invoked by courts and tribunals in various other cases. So that's within the judgment itself. Beyond the courtroom, there's a wonderful paper, also hot off the press, in Journal of Human Rights Practice by Chamberlain and Faree, that speaks to how climate litigation can have impacts outside of the courtroom. They explain that the litigation bought time. So with the challenges they brought, certain decisions couldn't be implemented, and that allowed public pressure to build. So all the while stopping this coal-fired power plant. Secondly, scientific research was developed as part of the litigation that has value far beyond the litigation. So illustrating the quantity of emissions that would be released as a result of this power plant and the impacts on human health and well-being. And so that kind of research can be mobilized through litigation. We also see separate but related license approvals being resisted because one government authority says, oh, shucks, I can't approve this if this other one's being challenged in litigation. We saw massive pressure on banks who ultimately withdrew financing for the project because of the litigation and the visibility it brought. And lastly, the judgment really yielded law reform. We saw the Department of Environmental, Forestry, Fishery and Environment release guidelines on climate impact assessment as part of environmental impact assessment processes. So we see some wonderful impacts beyond the courtroom, and these are the kinds that Joana was speaking about, the direct and indirect impacts. There are other sort of wonderful statements emerging from the Philippi horticultural case as well. Wonderful case study if any of you are looking to do more on socio-ecological impacts and litigation. There is ongoing challenges there. Please go and have a look at the work they do. And then lastly, I'll highlight some of the features of sustaining the wild coast. So here, within the judgment itself, we saw the courts highlight constitutional rights are at stake. And so in that context, the financial loss to Shell in exploring for oil and gas cannot justify the infringements of the applicant's constitutional rights. These are indigenous peoples who depend on the land and the coast, and whose cultural, participatory, and environmental rights would be harmed should the seismic survey that was planned go ahead. And so you see the court here prioritizing cultural practices interlinked with protection of the environment. And this is a powerful statement coming out about values. What is important to South Africans, people in South Africa? It's not money, it's not profits, it's people, it's people's cultural rights, it's people's environments, it's people's voices. And so litigation has that power as well to vindicate social movements like the Amadiba Crisis Committee that drove that litigation. So in another hot off the press paper that came out this December in Constitutional Court Review, I speak a little bit about how this judgment advances intersectionality. It recognizes intersecting forms of oppression that this community is exposed to, and then seeks to advance environmental and social justice as intersecting ideas, not explicitly, but in the various ways the court recognized the views of the indigenous people. Absent any science, these views were viewed as valuable about how climate is impacting their livelihoods, their cultural practices, and the environment. And so the community itself said, and this is a community leader, one of the heroes of South African environmental justice, Nonhle Mbatuma, but this is not just a victory for the communities fighting to protect the ocean on which they depend. It's a victory against capitalist extraction and destruction of humanity's common future. It's a victory for the whole planet. And of course, there are many other exploration processes being approved and that we are very much alive to, and that we need funds and support from the global community to address. So please keep that in mind, those listening and those with resources. The ongoing litigation I mentioned earlier, I won't touch on it due to time constraints, but you can find out more from the Center for Environmental Rights website. That center is one of the leading centers in South Africa driving and supporting social movements in response to climate change, and they're doing wonderful work. Their website is very well up to date and very useful resource. So lastly, what can we see from all of this? Well, again, Chamberlain and Fourie in their JHRP article recognize there's many critiques of litigation, but it's well established that provided it's used in combination with other strategies, litigation has its place. We've moved beyond evaluating litigation merely with reference to doctrine and judgments, but also how it's experienced outside of the courtroom. So they expose how litigation catalyzes and strengthens mobilization, builds alliances, energizes social movements when there are victories. We see that with Agenda, helps to frame and develop collective identity, builds institutional allies, and this is so important. For the Sustaining the Wild Coast case, we saw global actors and evidence coalesce with local actors to advance that victory. We see issues being spotlighted, we see voices that would not otherwise being heard coming to the fore. We get to reframe the dominant capitalist narratives or government narratives about short-termism and development. We get to disrupt power inequalities and overall adopt a more nuanced understanding of what litigation is. It's not a panacea, as Joanna was saying. It's part of something bigger, and of course can be a very powerful mechanism alongside other mechanisms. And so if you want to do further reading, not only the resources I've mentioned, but there's also a wonderful project that I'm part of leading through the GNHRE, the Global Network of Human Rights and the Environment. And one of the best things I think we've done is develop this annotated bibliography that we update all the time, which has a wealth of resources, including and especially by Global South voices, on climate litigation, justice issues, etc. So thank you. Sorry that I ran over time, but hopefully that was useful and gave a bit of insight on what's happening in South Africa.
Thank you very much, Melanie, for this really good, interesting presentation on the intersectional, I guess, dimension of litigation, and very situated examples that you provided regarding South Africa. So we do have again a few time for a couple of questions. Yes, Stephen, go ahead.
Sorry, I have to toggle screens here. Melanie, just for people who are less familiar with this distinction, you mentioned the different sort of varieties of climate approaches to climate litigation in a South African context, and you mentioned environmental constitutionalism, that approach versus ecological constitutionalism, and then also contrasted those with climate constitutionalism. Just sort of in a nutshell, how can those be usefully distinguished from one another? Ecological and environmental, for instance, for those people less familiar with those concepts.
Sure, yeah, that's a great question, and one that I'm still very much interrogating. But I think the overarching difference is around the primacy of nature, so in ecological constitutionalism. So the idea that nature itself is a subject of rights, whereas certainly transformative constitutionalism views environmental protection as primarily a human rights issue. Because I adopt a socio-ecological perspective, I view human rights and environmental protection as fundamentally coupled, to the point that they cannot be separated, and protection of one must entail protection of the other. But of course, there will be hard cases where these situations aren't mutually reinforcing and have to be resolved in very careful, nuanced ways. Whereas ecological constitution can be seen through the lens that nature has rights, and then those rights are kind of primary rights in that model of constitutionalism, and Ecuador is a very good example.
Thanks, that's useful. Thank you.
Thanks, Melanie. Ajibola, you can go ahead with your question.
All right, thank you very much. Yeah, my first question is to the first speaker. I would like to ask if there is a statistics or a rough estimate of the period, the time frame of climate litigation in some of the countries that the first speaker examined. I ask this question because in a country like Nigeria, we have not had issues that specifically mentioned climate change at the courts, litigation specifically mentioning climate change. However, we have had issues on the environment, like we see in the Niger Delta region, where there are several conflicts that has to do with the drilling of petroleum. And when you look at the time frame of litigation on some of these cases, it stretches to between 10 to 15 years. That is, it moves through 3 tiers of courts: the High Courts, the Court of Appeal, and the Supreme Court. And by the time you look at the time frame, some of the supposed gains will have been lost before you finally have a final pronouncement by the court. So I'd like to ask the first speaker, whether there is a time frame, statistics on the time frame on climate litigation in some of the country she has examined. Now, to the two of them, but more to the second speaker, I think we are mixing two things here. One is substantive law, and the other is procedural law. Substantive law is what the law says, like constitutionalism, environmental law, climate law. But procedural law is what happens in the court. Oh, by the way, let me introduce myself. My name is Ajibola Akanji. I'm an advocate and solicitor of the Supreme Court of Nigeria. I'm also a lecturer at the Faculty of Law, Licity University, and I'm a member of the Assembly of Future Arts. Now, as I was saying, there are two frames to law, the substantive part and the procedural part. In the Nigerian example, we've had instances whereby even when the substantive law appears reasonable enough to support climate change mitigation or proper environmental management, the procedural part of law becomes a barrier, a kind of procedure, court procedure, that allows cases to last for as much as 10, 15 years. So now my question to the next speaker is there anything like an or to everyone, is there anything like an international template, international legal policy that will provide templates for countries, particularly countries of the global south, in terms of both substantive climate law and procedural climate law? Thank you very much.
Thanks, Ajibola, for these three questions, as far as I could understand. So the first one had to do with the time frame of litigation cases, and if I understand correctly, you were asking Joanna whether there are any figure statistics about timeframes regarding the number of cases that she mentioned in her presentation.
Yes.
Joanna.
Thank you. Look, I'll answer as briefly as possible because Melanie has other questions to address. But I think that before specifically talking about the time frame, just to emphasize a point that Melanie made very well, which is the definition, the widely used definition for data collection and analysis also of climate mitigation is a very limited one. So there is a focus on those cases that have that explicit reference to climate change, whereas we know that there are many other cases, as Ajibola was saying, that are very important, that deal with coal or oil in Nigeria, for instance, and other countries, which currently haven't been considered in the database or analyzed as climate cases, but they're definitely, in terms of relevance, they are relevant. And this is a limitation of the definition that is mostly used due to resource constraints, because the issue with climate change is that it cuts across so many areas that if you try to collect everything, it becomes a database of millions of cases, which unfortunately, with the limited resources that we have, we can't maintain. So that's a practical explanation for why there's this limitation. And this is why it's so important what Melanie said, that in the Global South in particular, there is understanding and analysis of the much broader set of cases that are relevant, and that those are explored on a regional, national basis. So in terms of the time frame, I think what he said is also like, well, there are many cases that are not there, and it's true. And second, the analysis that we do of outcomes is the analysis as from, for instance, now I'm looking at the cases that have been decided by one instance of court, but it's true that in 3 years, that case would have been appealed, and then there will be a different decision. This is why in our analysis of outcomes, for instance, from last year to this year, the figure changed because there were 13 cases, I think, in Germany that were all dismissed at the same time. So what used to be a larger amount of outcomes that were positive or in favor of climate, then in the next year became a smaller amount because of those cases that were all dismissed at the same time. Of course, then these cases can be appealed, and then in a few years that will change. So that's the nature of litigation, and the slow pace of litigation too, which is a very frustrating, unsatisfactory pace. So the time frame is the time of the filing of the decisions that we find out, with the caveat that we are definitely short of looking at a much more broader, larger number of cases which are relevant to climate that are currently not analyzed.
Thanks, Joana. And then regarding the second question, yeah, Melanie, go ahead. Yeah, I saw you.
Sure. So there isn't, to my knowledge, an international standard, and perhaps Kelly can also chime in. But there are regional instruments, both in Latin America and Europe, so Aarhus and Escazú, that are proving useful in developing new norms and standards around access to court that address the access to court and other procedural issues. In South Africa, access to court is specifically dealt with in the Constitution, and there are some very progressive provisions that support access to court that then must be used to inform other rules. Of course, we don't have a perfect system at all, and there are many cases that have been dragging along for years and years and remain unresolved. So I completely take your point, and that's definitely one of the many limits of using litigation to address climate issues, and it's most obvious in the European Court of Human Rights. I think the cases that have been sort of dragging along there, but excitingly, those cases were, using the procedural rules available, prioritized, and are being heard by the broader tribunal rather than a limited tribunal. That's a very crude way of explaining the situation. But so there are workarounds. We need to figure out how to use those workarounds. When we develop our litigation strategy, we need to think about whether and when to use injunctive relief pending the outcome of longer term proceedings. I think one of the many reasons why we in South Africa haven't seen any kind of tort, or we call it delictual claims, is because those kinds of claims would take a very long time. So to claim damages, there's lots of discussion around how we can claim damages from corporations at the moment. But we haven't seen a case like that because it would take too long and be largely reactive and meaningless. Especially if we ended up not getting relief within a reasonable period of time. So you make a very valid point. I shared here the JHRP link because there are a couple of really good papers, one by Mediki Colombo and Ricate, and they speak about the potential of the Escazú agreement to influence access to justice in the future. And so that might be a nice, I've looked at it, but I haven't prepped on it for this presentation. It might be a nice one to look at to engage on your question further.
Thanks very much, Melanie, and thanks, Jibola, for these questions. So now I suggest that we move on to our next speaker, Kelly Matheson. And for I guess it won't be a presentation, but more of a Q&A exchange between Stephen and Kelly. And yeah, I think I will just give it over to you, Stephen and Kelly, and it will be a nice segue into the discussion that will follow.
Great. Thanks very much. And I want to thank Kelly, really, who's come right off of drafting and submitting an important legal brief this week when Christy Cooper, because of medical reasons, couldn't be able to join us today. And I feel I should at least mention that Christy's film, Youth v. Gov, is we've got the rights for the participants of this workshop or this webinar to view that film. And that information, I think, has been sent around, but we'll have follow-up information if you haven't received that yet, if you registered late for this. So it's possible to view that film if you haven't through the license that we've gotten. Now, Kelly and Christy, and I want to, yeah, Kelly and Christy have worked together for a while. And Kelly was really involved at the genesis of that project. And so I'm going to begin, Kelly, by asking you to think back a few years about when your cooperation began with Christy around the cases that our Children's Trust were then involved in. And if we could try to, I have a few questions for you. So if we could try to keep responses to a couple of minutes each for these questions, that would be great.
Well, first of all, thank you everyone for having me. And second, I want to apologize because I am also traveling. So I'm at a hotel, but I'm at the location where the 1945 peace negotiations happened to end World War I. I have this montage of children behind me, which I just think is perfectly fitting. So if the noise becomes a problem, let me know. But I think this is really fitting because it is the young among us that often shine the light of injustice on all of the wrongs, from the civil rights movement to gun control to immigration, all sorts of things. So when in 2010, when Mary Wood and Julia Olson decided to bring 50 different legal actions across the United States, this wave of legal actions in all 50 states and some international jurisdictions, it was groundbreaking to do a wave of rights-based cases. So Mary came to me and said, hey, would you by any chance be able to make films about these young plaintiffs? Because they are incredible, their voice needs to be elevated, and it will complement the strategic litigation. And so we said yes. And then I went to Christy and several other students at Montana State's University's Science and Natural History Film Program. And we made these first 10 short films that's launched the strategic litigation. And I'll keep it short there, Stephen, and we can go to the next bit.
Yeah, and by the way, by asking you to keep it short now, it doesn't preclude us following up on these in the general Q&A afterwards. So that's my hope, is that if there's more to uncover, we will have a chance to do that. I'd like to sort of ask you, as far as this general approach that's been taken, I think that the Juliana case and its evolution and its origins really highlight a really interesting point, sort of trifecta between science, between legal theory and strategy, and activism and storytelling. That sounds like more than three. So but I think the activism and storytelling are part and parcel of one another. And so I was hoping you might be able to elaborate a little bit on that too, as far as the development of the case and how actually the storytelling around it, including the film and the films that you just mentioned, have been sort of integral to that.
Yeah, absolutely. And I should go back to 2005 because visuals really launched this case. Mary Wood in 2005 was watching the visuals of Katrina slam up against the Gulf Coast, displace thousands of people, kill over 1,800 people. And that's when she decided to turn her scholarship to finding a systemic solution to the climate issue. Julia Olson, Inconvenient Truth. So you've got this link of visuals throughout this entire campaign supporting young people. So when it came to Youth versus Gov, one of the really interesting components, as Stephen mentioned, is that it's a perfect trifecta. It's the coming together of law, climate science, and storytelling. So when we did these films, the first films, we highlighted the youth voice. That was backed up and corroborated with scientists and with the law to give them the power behind what they were saying, to give them the evidence behind what they were saying. And for those of you who've seen Youth versus Gov, which is this absolutely incredible award-winning documentary that Christy worked on, she does an incredible job of centering the young people in this film, but bringing in the law and making this very complex case understandable. And then on top of it, she does an outstanding job of graphically showing the timeline of all of the evidence, everything the government knew. And they knew fossil fuels was going to endanger humanity, particularly young people. And then they continued to permit it, subsidize it, and promote a fossil fuel economy. So I think Christy wove all those together. And then to take the next step, lawyers are storytellers. When we walk into a courtroom, and I can tell you more about this, Stephen, if you want, or anyone, but when we walk into a courtroom, we are weaving together a narrative. And for those of you who saw Held versus Montana, that case was a story. So I'll pass it back to you.
I think that's an interesting way of transitioning into talking about a couple of the cases. But I would like you, and I'll take this moment just to ask our everybody in the webinar here, if you're not speaking, to make sure maybe your mic is muted, because we're getting some voices, I think, in the background. But could you elaborate a little bit on that storytelling dimension in court cases? And then it would be interesting to hear a little bit about the legal approach that you think is worth bringing up as some examples right now. You mentioned Held versus Montana, but of course we got the Juliana versus the U.S. case as well, which is the subject of the film. So I would love to hear you elaborate just a little bit on that last point you made.
So I'll go back to the last question that was asked, is there an international template for cases? There isn't, but in every constitution everywhere in the world, there is a right to life. There is a right to non-discrimination. There is a right to equality. There is a right often to health. So the beautiful thing about the Juliana case is it's 21 young people that brought a case against the U.S. government for the U.S. government's actions in promoting this fossil fuel system and violating their constitutional rights. So while it has to be tailored in every jurisdiction around the world, it is possible to tailor that legal theory pretty much everywhere. And that's what we did. And that's what we're doing in our state cases. We have a national strategy, an international strategy, and a state strategy. So Held versus Montana is similar to the Juliana case in that it's 16 young people that took the state of Montana to court for violating their constitutional rights to life, happiness, dignity, etc., all premised on their right to a healthy environment. And so they go into court, and then if you make it to court, and that is the key, is getting into court, because then you can tell the story. Then you can show the evidence. Because in a court of law, facts are facts and alternative facts are perjury. So when you get the government into court, they don't have a story to tell. And the reason why they don't have a story to tell is because they do not have the facts on their side. So Held versus Montana, 2-week trial was planned. We presented our case, and the story was weaving expert evidence, and then a youth plaintiff would tell their story, and then another expert would corroborate that, and another child would tell their story about how they were harmed and why they're involved with this. And that wove throughout the whole entire trial. Second week comes along, Montana has their turn to take the stand. They literally did not present a case. And 2 months later, a 100+ page decision finding fully for the young people on the facts they presented and the conclusions of law they presented was signed by Judge Kathy Seeley.
I think that it's a really interesting example that you've brought up there, because when I think about the film Youth v. Gov, there's a really interesting moment when former Senator Sheldon Whitehouse is talking exactly about the point that you just made, that in fact facts matter in a court in ways that you can get away with messing around with facts outside of the courthouse, in the political sphere, and in the messier sort of socio-cultural sort of media landscape. And that, I think, raises an interesting question about where the Juliana case, after 4 years, ran into an obstacle And the film highlights this, I think, in a really, so I can't stress enough what an opportunity it is if you don't have access to the film otherwise, to take advantage of the license we've gotten in here for all these participants to watch the film. The declaratory relief issue was what sort of after 4 years posed an obstacle, and I was hoping you might just really briefly be able to explain that in this context.
Yeah, sure. So in order to go to trial, you have to go through all those procedural hurdles that we've talked about a little bit. And in this case, they had to show, the young people, the 21 young people, had to show they were harmed, the government caused their harm, and the court could do something about it. So the Ninth Circuit basically said there's copious amounts of evidence to show young people, and these particular young people have been harmed, and copious amounts of evidence to show that the government caused the harm. But they ran into redressability challenges. Basically, they got the law wrong. A court can give declaratory relief and a court can give injunctive relief. But they said, nope, we can't give the injunctive relief. So what the young people did is said, okay, fine. Then we are going to go back and we will amend our complaint. And we will say, just declare what the law is. Just declare that we have this constitutional right. And so that went back to the trial judge. And in June of this year, she came back with this absolutely powerful decision that said precisely that. This is what courts, their core responsibility is to do, is to declare what the law is, declare what constitutional rights are. So that decision by Judge Ann Aiken in June set the young people back on trial. Now the question mark is the Biden administration going to fight these kids from getting access to justice at the same level the Trump administration did or not? And that is yet to be seen. And this is where Christie's film is, it was released 2 years ago, but it's still so powerful because the film was seen by Biden's transition team. It was seen by John Kerry. It's been awarded numerous awards, film festivals all over the world. It has an educational curriculum. So this film is still making a difference.
Okay, that's that's great to hear that. And by the way, I mean, I think one of the powerful sort of storytelling elements of that film is often implicit, but it's very clear, is that where when the difficulty posed by just being able to get into the trial, to just be able to begin the trial. And a lot of people who are not lawyers themselves may not be familiar exactly with what that process involves and how much you've got to fight to be able to actually get to trial. And I think the court or the film really admirably gives an inside view of that process, both for the plaintiffs, for the lawyers, but also about the process itself and how fraught it is with vulnerabilities along the way that actually have to be dealt with. So I feel free to follow up comment on that, but right after your next comment, I'd like to maybe suggest, because we've got about 30 minutes left, that we move into a more open Q&A so that we can allow other voices to come in, and if they have questions for you and for anyone else here. So do you have any thoughts about that process, which I think the film does a wonderful job in its own storytelling of illuminating?
About illuminating the trial process.
Yeah, illuminating the trial process, but also exactly how difficult that is. I mean, people in popular culture, they see these courtroom dramas, which give very unrealistic ideas exactly about what that process is like and how it can be, and the sort of power to seek that kind of injunctive relief, almost, taking away that long process in the middle and all of the grief that people have to go through in the meantime.
Yeah, the film did an excellent job of showing the months and the years and the pages of evidence, like tens of thousands of pages that the US government dumped on us. And when you see the film, my favorite scene is actually the deposition scene, because in a lot of the international litigation that's happening, it doesn't go to trial, it has hearings, right? So it's the lawyers up there arguing. against each other, and the young people don't take the stand, and the young people aren't deposed. And the deposition scene just shows you what lengths the government will go to really bully these young people. What they did during the depositions was completely inappropriate, completely inappropriate. And so these young people are not only in front of the media and in front of the court, but they're going through depositions like this. And then they're taking the stand. But I have to say, for the plaintiffs that took the stand in Montana, they're like, this feels real. It feels tangible. Change feels tangible. They felt heard.
Yeah.
And just to give young people the voice to stand up there under oath and speak truth to power and have their voice heard, because it was broadcast throughout the world, was absolutely incredible. And I'll end with one anecdote. The trial, as I mentioned, ended early because the state didn't present a case. So we had to come up with a closing argument incredibly fast. So that night at the hotel room where everyone was staying, the lawyer sat down with the young people and said, "This is your closing argument. Let's write it together."
Wow.
The lawyer had to present it, but they sat there for a couple minutes, and then the first one spoke, and then the second one spoke. That closing argument is their words. And if those of you who haven't seen it, it's absolutely powerful. And that's why we have to elevate the voices of young people.
Thanks very much, Kelly. Thanks very much. I'm sure there's going to probably be more questions for you and for our other speakers. So I want to maybe turn it back over. Well, turn it to Rebecca now, who's going to be coming in and moderating this last part of the webinar today. Please, Rebecca, over to you.
Thanks a lot. And first, thank you to all the speakers for the presentations that you gave. So I have the pleasure to invite all the participants to contribute your thoughts and comments and questions to the remaining 30 minutes of our forum. And yeah, I will profit from my role as the moderator of this discussion to ask the first question. And I had a question about climate justice, and it is something that you already mentioned, and that was especially visible in Melanie's presentation. So essentially my question comes down to, how good is climate change litigation actually at advancing climate justice? And I am asking this question because some of the very successful landmark cases, especially in the global north, such as the German Neubauer case or also the Dutch Uganda case, are actually based on an emissions trajectory that would lead us more towards a 2 degrees Celsius trajectory, even though we know that even below a 1.5 degrees trajectory, there are climate change impacts which are catastrophic, for example, for some of our world's coastal communities. So the question that I want to ask is what role those different dimensions of justice, like intergenerational justice, environmental justice, but also interspecies justice, social justice, and post-colonial dimensions of justice can play in shaping climate change litigation cases, and how the more intersectional approaches which Melanie introduced to us in her presentation can help to advance those different dimensions of justice in climate change litigation, also in global north contexts. So this question is really to all three of you, and I don't know who wants to go first.
I can say something to that, Rebecca, because our cases are rooted in science. And I think, Joana said something that really struck me, and it's courts aren't challenging the science anymore. So we need to be pursuing the proper science. 1.5, we all know, and everyone agrees on, for the most part, is almost universally agreed that it is a political target that's not based in science. We also know from the IPCC and every other scientist out there that 1.5 is not safe and not protective of human rights, not safe for humanity, particularly for the global south. But yet our field is still presenting 1.5 as the standard. And so in cases like Neubauer, cases like Yerhenda, and cases like the Clemenzot case that just came down, the judges are sanctioning 1.5 is the proxy legal standard. So that's happening in Europe. On the other side of the ocean in the US, the scientists are presenting the science, Dr. Steve Running, Mr. Pete Erickson, et cetera. And the courts are doing what Joanna said, they are not challenging the science, nor is the government. They know that 1.5 is not safe. So we as a field have to be presenting that correct science to them, because that's the only way we're going to get justice. You cannot have effective remedies if we have 1.5 as the legal standard.
Yeah, I'm happy to chime in too. Sort of, this isn't as big an issue in project-based climate litigation, where the focus is on the science relative to that particular project. So it comes in more when there's a sort of strategic litigation aimed at mitigation. And of course, that's not the focus of Global South climate litigation, because our focus isn't on mitigating at the higher level. It would be kind of ridiculous to ask our government to reduce its emissions. Like, that's not something we would be able to do, or its mitigation ambition. We could ask our government to comply with the targets it's set, but not to increase. So instead, the litigation targets particular projects that will threaten the targets that have been set. But I think there's a very good question around justice and whether these cases aimed at keeping us within certain targets are, whether and to what extent they're aligned with climate justice. So if you think of the alternative, if those cases weren't brought, Agenda and Neubauer and similar cases, the government wouldn't even be trying to stick to 2 degrees, right? It would be emitting without consideration of that commitment, or potentially. So there's at least an effort to keep government accountable to some standard, even if that standard isn't going to solve the temperature rise issue and protect communities in some kind of absolute way. So I do think unwittingly the courts have advanced some degree of climate justice through those kinds of mitigation decisions. Not enough is certainly a valid critique, and the idea that climate science is also evolving all the time, and we're learning that the targets we set years ago in international policy are no longer sufficient, and for the lawyers and the climate science to catch up and to present that evidence is crucial, as Kelly was saying.
Yes, thank you, Rebecca, for this question. I think I will address it, bringing points that both Melanie and Kelly made, but also so on the narrative side of what Kelly was saying, and then also in the insufficiency that Melanie brought. But I think the way I would see this is it's definitely insufficient, and we see that, that's the unfortunately the narrative, not the narrative, but the reality of the climate action so far. So if you look at the global stocktake, for instance, that is what we rely on, and it's a clever instrument that the Paris Agreement came up with, and that now is what we depend on. You look at the report on the results of the stocktake, and it's always that same story. It's insufficient. It's not taking us to the target that is needed. So there is, on one hand, that's the reality, really, that the efforts are never enough. But at the same time, I guess if you don't have the teeth that the courts can give, then we're missing even more teeth in this story. And I think with the justice in particular angle, maybe, you know, it's always too much to ask for courts to provide justice, but what courts and these cases in particular have given to justice, to an understanding of justice, I see as a way to show that there is injustice in how climate affects populations in different ways. So we would say this so many times, that the distributive angle of climate is one that those who cause the impacts suffer less than those that are going to suffer. And what do you do with that information? That's again where I think the litigation can be one of the few ways to put that additional pressure. And this takes us to the loss and damage, to the conversations where, of course, the international negotiations that happened last week in Dubai and many other COPs, they are not simply accepting that there was going to be wide compensation to everyone, but that's still what the fund will seek, and that in some ways that the domestic litigation is feeding into that narrative of a compensation that will be necessary to correct the global injustice of this problem.
Thanks a lot, and thanks for your answers. I would like to hand over to Rebecca, who had a question, who raised her hand first. Please go ahead.
Thanks, Rebecca. My question concerns non-human creatures, and I was wondering if the speakers have any examples or examples of cases of litigation that might have challenged some of the worst injustices that we see against, say, farm animals in intensive rearing and so on. I'm quite interested in food production systems, and so given that some of the big businesses' treatment of non-human animals really needs to be considered in relation to animal welfare, I'm just wondering what role litigation might have in challenging some of those, some of the worst treatment, the worst injustices committed against non-human animals in the food system, and how in the future that might link to litigation against businesses in relation to the harm that these systems cause human beings and the environment more generally.
I can say something very brief about that. I'm aware that there is one case in the UK challenging emissions related to farmed animal production, and I'm not sure that if it's ongoing. I haven't checked recently, but that's an important case, and hopefully other cases like it will be pursued elsewhere in the world. But what I can say with a bit more authority is that in this idea of the just transition, so transitioning away from harmful industries that contribute to the climate crisis, it's increasingly being recognized that agriculture is one of the biggest emitting sectors, and that animal agriculture needs a rapid and equitable transition away from intensive animal agriculture. So there is literature around that, including by Charlotte Blattner, on the just transition and animal agriculture, and some just transition policies, including South Africa's, speak to the need to transform the agricultural sector. Not necessarily in our context in South Africa, not with reference to farmed animals specifically, but there are major groups involved in mobilizing to recognize these links between farmed animal production and climate change. And one of them is the Open Wing Alliance that's advancing caged-free egg production and has a major campaign trying to hold corporations accountable in Africa and beyond. And so there are efforts going on, but I'm not aware of farmed animal climate litigation beyond that one example that I'm not particularly familiar with. Joanna may be able to speak to it. There are, of course, cases in Ecuador and Colombia that speak to the need to protect non-human life using ecological constitutionalist approaches. So there's Future Generations that recognizes the Amazon forest in Colombia as a subject of rights. And then there's this, I'm less familiar with the Ecuadorian litigation recognizing nature's rights. It has rights, and there's litigation all around the world emerging on this subject. But animals, as opposed to nature or as a part of nature, slightly less so. I know that the Ecuadorian case was about a monkey, if I'm not mistaken. So there's a growing discourse and movement in this space.
Thank you.
Thank you, Rebecca, and I can follow from what Melanie was saying in terms of the existing cases and also some initiatives that are looking into this. So first, in terms of the existing cases, you're absolutely right that there are few that have made these explicit links within the case of climate and animal protection and animal farming. Again, that's not to say that many other cases that are relevant are not climate ones. So there's always that caveat, but the cases that have made these this explicit links are few. The one that Melanie was mentioning in the UK is an interesting one, which was dismissed. So it's a case called Human Being versus the UK, and it was filed before the European Court of Human Rights. And what this case is doing is saying that factory farming in the UK is taking place in breach to obligations under Articles 2, 3, and 8 of the Convention for failing to address risks of climate crisis, pandemics, and antibiotic resistance. So the case was brought in 2022, and it was dismissed earlier this year, and it was declared inadmissible. So that's the example Melanie mentioned. And then there are a few other cases in the US. There's one regarding poultry farming in California. So a few cases that have made this explicit link, but I would refer you to a really amazing initiative that is led by Yale. So Yale has Yale University. They have a lab or a center. I have to check exactly the name. I think it's a center on climate and animal farming. And those guys, Doug has, I think, led for a few years this work, and they haven't been directly involved, I think, in any case, but they bring a lot of material and have supported, I think, some of the potential cases around these topics. And yeah, so that's, I think, my answer, that sometimes the link is not explicit. And the same with biodiversity. You know, the biodiversity and climate are interconnected, and not always the two arguments are brought together. Sometimes they are. And what we're seeing now is more of this, where the two were parallel, and the same with animal farming. Sometimes there is this overlapping in terms of arguments that we are starting to see more. I think we'll see even more. And then related cases with biodiversity agriculture, you could see the ones involving soy and meat production in Brazil, leading to deforestation, leading to emissions. Those also, of course, have a strong connection with animal farming or grazing for animal feed. So that I can see, and we pointed this in our global trends report, that this is going to become clearer, and there are increasingly more examples that we'll be seeing in the future.
Thanks.
Thank you. Kelly, do you want to respond to that question as well? Or otherwise I'll hand over to Raki, who also
No, we don't do anything at that intersection.
Okay, Raki, do you want to unmute? Yeah, go ahead.
Yes, thank you so much. Sorry, I deliberately turned off my camera for fear of emotional, what is the word? Of being emotional. So basically, I've experienced multiple human rights issues over the past 3 years, some indirectly and some directly related to climate change. The issues around directly related to climate change is that we've had multiple heat waves in South Africa during this spring and this summer. And my minor in a school has been made to undertake intense physical activities during this time, even though I have myself walked onto the field and approached the coach and questioned whether he was aware of the fact that we were undergoing a heat wave. He said he belonged to a professional sporting body, and and this is what they undertake. In the absence of legislation to protect the minor, I had to walk off the field. I did escalate the issue to the head coach, but nothing was done. And I've actually spoken out at Presidential Climate Commission meetings in South Africa to stop these attacks on my minor. And this actually occurred. I'm a climate scientist by training, so I've noticed a trend where when I'm preparing my slides, for example, advocating against intense physical activities during heat waves, these it translates into reality whereby my minor is subjected to these intense physical activities. And it wasn't only in the recent heat wave, in the recent spring and summer heat wave this summer, and I was talking about El Nino events that would intensify the heat that we would experience in South Africa. And prior to this, in January as well, there were heat waves, and the same thing occurred. It is a trend. Despite the fact that South African Weather Services, the National Weather Services, releases heat wave warnings. Everything that is said on the heat wave on the National Weather Services warning translates into the opposite of what happens in reality at his school. But the child won't talk. There was one instance where he was made to bat for 3.5 hours under intense heat. I couldn't even stand myself in the sun, in the direct sun, but he had his helmet on the entire 3.5 hours, batting and running across that field. Now, this is a human rights issue, and I just don't know how to take it further, because none of the legal institutions will, they say that I have nothing. I've got no evidence. And I've approached the school on multiple occasions and nothing seems to be done. I'm really at my wit's end as to how to make these attacks on me and my family stop, because you know, they say that I just don't have the evidence, even though I am seeing the trend of the events that that are occurring. I'm gonna stop talking because I think that's all I have to say. Thank you. If any advice, any way forward to stop this, I'd really help. It would really help, and I really appreciate it. Thank you so much.
I've put some suggestions in the chat, Rakia. I'm very sorry to hear about what you've been going through, and I think that there's certainly, if lawyers are able to connect the dots between climate harms and you know, the need to protect the most vulnerable and act in the best interest of the child, there's certainly a case to be developed around proper protocol for learners at schools in the face of extreme weather events. And the Constitution protects rights of the child alongside the right to an environment not harmful to health or well-being. And I think there's potentially a case to be made out. So, you know, it's worth approaching organizations like Equal Education and the Center for Children's Rights, which is based at the University of Pretoria. They both do very good work in this area. And if you haven't already, it's worth trying to connect with them. Of course, at this time of year, I imagine the very overstretched small teams will be taking a bit of leave. But, you know, in the new year, you know, second or third week of Jan, it would be worth reaching out to them if you haven't already.
I don't have anything that I can add to say to help you and the troubles you're facing. But on Sunday, we did file a new case called Genesis B versus EPA. And it's a 100+ page complaint. It is all about equal protection and discrimination. It's all about how the government knew, the EPA in this case, that they were harming children. And that sounds similar to the story you're telling. The school knows they're harming children, but yet from the heat waves, but they're still allowing it to happen. So I can drop that. I think someone's going to drop the name of the case in the chat. And a link to it. There's a press release and a complaint. And that might be something to help think about how to approach the challenge legally. And if it is helpful, then we can talk about that anytime.
Thanks
so much.
for,
thank you.
Thank you for giving those answers. I want to conclude our discussion with a last question from my side, which refers to something that briefly came up in Joana's presentation, where she mentioned litigation cases which are not aiming at advancing climate goals, but at precisely the contrary. And so I wanted to ask what instances of social and political backlash there are in response to climate change litigation, and how they may risk to undermine the transformative potential of the litigation cases, and also how the different actors who are involved in climate litigation cases, especially the plaintiffs, and even more so if they are children, experience those instances of social and political backlash.
Thank you, Rebecca. And I'm conscious here of the time, so I will give a very short answer to say that understanding the backlash of litigation or cases that are not aligned is a very important thing to do that I don't think we have done well enough. So we tend to have this tendency to focus on the cases that are successful, the arguments that are aligned with climate. And we even in studying a case, you will see that there is a tendency to forget about how the defenders are defending themselves. So I think this is a very important invitation for analysis, attention to be drawn to the defense side, to the cases that are not aligned. And in particular, what I would like to emphasize in my answer is the ISDS litigation, so the arbitration investors dispute resolutions that are brought against governments by powerful corporations that ultimately put governments in a very difficult situation where even when they're trying to pass a policy and legislate and take actions towards reducing emissions, they would be responding to this important problem, but then facing a hugely expensive potential arbitration case brought by companies who are challenging their right to continue, for instance, exploring coal. And we've seen already quite a few of these cases, including in response directly or indirectly to the Urgenda precedent, where you have RWE and Uniper filing cases against the Dutch government challenging the phase out of coal. So the backlash, the anti-litigation is quite broad, and I think it's not well enough understood, and very important for us to explore, understand, map it better.
I want to add something super quickly. One, advancing child rights strategic litigation. They're a group, ACERL, is working with the Center for Child Policy or Center for Child Law out of Pretoria, and they've done a document on how to work with youth plaintiffs in litigation. It's outstanding. So if you're ever working with young people, like, that's a go-to resource. And with our young people, we've been, working with them since 2010. We have actually a trauma-informed care workplace and trauma-informed care litigation, where we have a trauma consultant with us. So when we went to Montana, our trauma consultant went with us and was there for the young people, because there is backlash from, the government mostly. Our young people aren't seeing government or backlash from the media, fortunately, very slightly, but not a lot. The media is really positive, but even their friends, some of them lose friends because of this. So they're young people. So making sure you have all those best policies and practices in place as outlined by ACERL. And then on top of it, setting aside the resources to make sure you can do good communications and have that consultant is so key.
And very briefly, I can add that there's been some really interesting developments in the field of preventing strategic litigation against public participation. So we know one of the mechanisms that corporations use is they litigate to stifle social movements who are trying to deal with climate change and other issues. And in South Africa, a SLAP case of that nature was taken to the Constitutional Court last year, and a SLAP defense was developed by the Constitutional Court, relying on the right to freedom of expression. So certainly these social movements face a lot of hurdles and resistance, and it's a constant struggle. So Raki, we understand where you're coming from. These people that are litigating are on an uphill against very powerful actors. And, there's this call for all of us to be firefighters in this time of climate change. It's not a fire we're going to put out, but one we have to try and keep at bay.
Thanks a lot. And with that, I will hand back to Gilles to wrap up the forum.
Thanks, Rebecca, and thanks everyone. Yes, we're already running out of time, but this has been a really thought-provoking and really fascinating session, and I really want to thank our speakers today, Joana Setzer, Melanie Murcott, and Kelly Matheson. Thanks also to you, Rebecca, for facilitating this discussion. Obviously, I also want to thank Stephen Hartman from the Bridges Coalition for coordinating this Future Earth Bridges joint webinar, which probably won't be the last event of this type. And I also want to say thanks to my colleagues Pavel and Colleen from the Future Earth Pathways Initiative, who have been helping in making this webinar run smoothly. If you found the session interesting and you would like to explore the topic further, together with our speakers, we have compiled a reading list with additional materials and resources that will add additional information to the discussion we've just had today. We are sharing a link to this document now in the chat. If you're watching this online after the webinar, there will be a link to it also under the video, probably somewhere. And I also want to say that this has been a bit of a special session for me today, because this was my last Pathways Forum with the Pathways Initiative. I will begin a new adventure next year, still focused on transformations towards better futures, but at a much more local scale. But it has been an absolute pleasure to be there for the first 11 Pathways Forums, and I'm glad to say that it's not the end of the webinar series, far from it. There are many more to come next year, thanks to the Future Earth Pathways Initiative team. And in fact, if you'd like to stay informed of our upcoming events, I encourage you to subscribe to our Pathways newsletter, to follow us on LinkedIn or Mastodon, and Colin is providing links to all of these in the chat box. And lastly, if you would like to watch the recording of this session, share it with other people, or if you'd like to watch other Pathways Forums that we've recorded in the past, you can also visit our Pathways Forum webpage, and there should be a link in the chat appearing any second. So with this, I want to conclude by thanking you all, speakers, participants, all the people who have facilitated this webinar. I wish you all a wonderful end of year, and I hope to see you again online or in person. And until then, take care.